Hello, new lawyers. My name is Jared Placitella. I'm co-chair of the Communications Publications Committee. And today I'm speaking with Sarah McEahern of Zaner Harden Law. Hi, Sarah, how are you?
I'm good. How are you doing?
Great, thank you. Thanks for being on with us to discuss yours and former NLD Chair Kurt Zaner's recent $8.4 million verdict.
Yes, happy to be here.
Yeah, first of all, congratulations. It's a fabulous result for your client, and I know your client was very privileged to have you both as their advocate.
Thank you.
So tell us a little bit more about the case.
Sure. So in our case, our client is an electrician. He has his own electrician company. It's just him and his wife, and they go around connecting mobile homes to power. This is kind of their niche. It's in it's the western slope of Colorado, so more rural area, pretty far away from Denver. And one day he was going to work and just doing this normal hookup. He had done 3 of them that day on this mobile home site, and he got electrocuted. He had an electric shock in the process of working. So before he got there, kind of rewind several months, Q3 Contracting was the main defendant in our case. They were responsible way before my client John got there to connect this electrical box to the transformer. So effectively connecting it to the grid. So they're a subcontractor of Xcel Energy, which is the main utility provider in Colorado. And they were supposed to connect these 3 huge wires. Each one is about, that thick, from the transformer coming into this electrical box on the side of it. It had 2 meters on each side, or it was going to have 2 meters on each side. And they were supposed to connect those 3 wires inside the box, but instead they left those 3 wires loose, closed the box, locked it up, and then energized it, turned the power on. There was 3 times that they were supposed to check before they closed the box, again before they put the power on, and then after they put the power on, they were supposed to check to make sure these wires were connected properly. They didn't do that any of the 3 times. And that resulted in this box being energized. So the whole outside of the box was emitting energy effectively. And so anyone walking by, if they were grounded, they would get shocked by any metal piece that was conductive on the electric box. So my client, he was there his day for simple task that he was doing, and there was caution tape because there was a ditch where his wires were going to be fed to the mobile home. He went to step over the ditch, had his hand resting, you can't really see very well, but he had his hand resting on a gas meter, and his elbow touched the outside clip of this pedestal, and that grounded him, connected the circuit or closed the circuit. And he was shocked for, we think, 20 to 45 seconds. We know this because his wife, she was working across from him in the ditch, and she couldn't see him. She was down in the ditch over on the other side, but she started hearing this weird noise. And she testified at trial that, sometimes he makes weird noises. So she was just like, "John, you okay?" Right. No response. "John, you okay?" No response. She asked him a 3rd time, and then she heard weird noises. She kind of couldn't describe what they were at first, but then she got up out of the ditch. She saw him stuck there, and he was like this, ran over to him. Before she could get to him, he finally fell off of it. And he has suffered neurocognitive disorder, which has given him memory issues and attention issues, and as well as developing complex regional pain syndrome, or CRPS.
So what hurdles did you face either before trial or during trial that you really had to get around to accurately present the case to the jury as you wanted?
Yeah, so one of the biggest hurdles was, from early on, when we first met with John, who's the plaintiff in the case, He grew up in Western Colorado. He's a tough guy, and he has this tough guy persona. He's a really sweet guy, but he doesn't complain about anything. He's really, he's like, "How are you doing, John?" And he's in terrible pain according to objective tests, but he's like, "Oh, I'm okay." And so his wife would sit next to him and say, "No, you're not okay. Last night you were up all night crying because you were in such terrible pain." But of course, he didn't want to say that to us. And so being able to draw that out of him so that we could convey to the jury, not only is he's a tough guy, we tried the case in Denver to, urban jury, and they don't really know what it's like to grow up on the Western Slope. And one of the lay witnesses that testified, his friend, talked about being rednecks and doing redneck things and trying to bring in his background into the case. And the important thing for that is he's not always going to look hurt. He's not going to say that he's hurt. He's not going to complain about being hurt. But being able to get the jury to award pain and suffering damages and impairment damages and understand that he is in a lot of pain, that was a big challenge for us.
Yeah, I think that's very effective. Instead of having the plaintiff obviously talk about their own pain, but you had the wife who was on the scene. You've had, I think, bringing in the friend who's kind of an unbiased third party is very helpful. Is that kind of the way you were trying to build this damages picture, was by outsider perspective, because you had such difficulty in having the client open up?
Exactly. So his wife was a key witness in all of it, because she's there all the time. They work together, they live together. She was going to all of his doctor's appointments. So she was really helpful in conveying all the things that he's going through and things that he might share with her that he wouldn't, share with anyone else. We also had several other lay witnesses. So one of his best friends came and testified. We had one of his work mentors who has seen him, throughout the years, and his ability to work and be excited about work and that sort of thing, testifying. He was on the stand for maybe 7 or 8 minutes. It was very brief, but it was just another snapshot of this person knows him well and could tell, even if it's just a minor change in his face or his affect, because he knows him so well. We also had an employer, a customer of, employer, customer of his,
right,
in his electrician business. She also testified just for a few minutes. And the other person that was really helpful in conveying his pain was his physical therapist, because she sees him, she had seen him over the course of at least a year and a half, once a week, twice a week, and then once every 2 weeks. It was kind of gradually over the time weaning off, but she saw him consistently and could see over a long period of time, versus his main treating doctor says, "Well, he complained to me about this time," or it was more powerful to have the physical therapist, who's maybe minor in these types of injuries, but her testimony was also really powerful in that way.
right, but who also has regular exposure, just like the other witnesses who you called. And you could tell by the strength and the amount of the damages award that you both received, that the jury really grasped on to that whole picture person that you painted through these various witnesses.
Mm-hmm.
Now, I know, talking offline, that your strategy going in was to kind of stay away from the technical aspects of electricity, current, etc., about how that causes disease, and that the defense want to make that the focus of their defense. So how did you approach that, in cross-examining their witnesses, or how did you do that to kind of shift your strategy at trial? Talk me through that a little bit.
Yeah, so the voltage of this shock was 120 volts. And so as we started the case and as we were litigating it, during discovery, we didn't think that was an issue, right? We had been involved in an electrical injury case previously where it was also 120 volts, and no one ever said anything about that being an issue, right? But then we get expert disclosures and they're saying no one could ever be injured from 120 volts. This is a common household voltage. It's very low. There's no way that he could have suffered all of these injuries from 120 volts. So they hired this biomedical engineer, and he provided those opinions saying, number one, no one gets hurt from 120 volts. There was no burn marks on John's hands. So that's further evidence that he couldn't have been harmed by this shock. And also opined that he couldn't have been stuck there for 30 to 45 seconds because he wasn't grabbing on with both hands. His elbow was in contact with one, so there's no way that his elbow wouldn't have just jerked away after 0.1 seconds or 100 milliseconds. So we got our own expert. I talked to several people and ended up hiring Michael Morse. He's out of California. He's also a biomedical engineer, and he deals with these sort of electrical injuries all the time. And so we did that so we didn't, we wanted to be able to counter them and have our own expert there. But at the same time, we were still conveying the fact of, or trying to promote the theme of this is not, it's not your average 120 volts. This isn't, just like a way for them to deflect. And so, even our own expert, he's like, I can't calculate the current, the amperage, because I wasn't there. We don't know exactly what was going through his body at that time. No one was there to measure it. We know the voltage itself was 120 volts, but how much was going through his body, how long it was going through his body, we have to rely on the eyewitness testimony, the wife who was there. And so we tried to flip it, and they're trying to call his wife a liar. She was there. She saw it with her own eyes that he was stuck there. Why would she say that? Why would, there was no other explanation for this injury besides this shock. The expert that we had, he was pretty humble in not trying to say that 120 volts is always going to be really terrible, but we did have statistics and we put all of those up as well. But we're relying a lot also on just what happens in the field. We had a master electrician as an expert as well. He doesn't know all of the science behind it. He can't calculate the current, but he knows he's been shocked himself, and he's seen people that have been shocked. And a lot of times you're lucky enough to walk away, brush yourself off, and big deal. But sometimes it's really bad. Sometimes there are fatal shocks from 120 volts. And that's why there's so many protections in place, GFCI protectors and all these, you're plugging in those little things to baby proof it for your kids. One of the things that I thought was most effective, Kurt did when, the other expert was up saying how there's no way that anyone could ever be hurt, is we looked at the clock for 40 seconds and let 40 seconds pass in silence, saying, let's just show the jury how long this 40 seconds is, that John was being shocked for. And at the end of that, asked the expert, now would you're saying there's no way that he could have been shocked or injured by a shock that lasted that long. It was a painful 40 seconds. And the expert said, no way. So the next question was, okay, well, would you volunteer to be shocked for 40 seconds by 120 volts? And he was like, oh, I've been shocked enough, so I wouldn't want to do that.
Well, I'm shocked that wasn't a standing objection, Your Honor. Don't answer that. But I thought that, I read that in one of the articles, and I thought that was really effective, because I remember just from taking any kind of standardized practice test, you could remember how long 40 seconds is without doing anything and just looking at a clock. We deal with similar type things in asbestos cases, where a defense is that a certain type of asbestos does not cause disease in any amount. So you could use any kind of hyperbole analogy and kind of undercut the defense position by taking their position to an extreme point. And once that's their position, just like 120 volts can't cause injury, you could take it to that extreme and they're stuck in. And I thought that was a really effective point when reading about it that, you guys both did.
Right. Yeah. I think the jury really got it.
So before we go, do you have any other takeaways that, us others in the caucus could take for our future cases? Any wisdom to impart?
So one of the other issues that we dealt with was prior conditions, right? So pre-existing conditions. Our client had untreated sleep apnea and carpal tunnel. And so both of those kind of interrelate to a lot of the symptoms that he had. He has pain in his hands. And so they're saying, oh, it must be carpal tunnel. Well, his carpal tunnel treatment happened 9 years before, and 7 years before. He had 5 visits where he got injections, and he complained, and then nothing for 7 years. And then after this injury, he went to specialist after specialist trying to treat all of his symptoms. And so one of the things that we found to be really effective is to make a timeline, a visual timeline of all of that treatment. And so you see all of these different visits that were happening. And then at the same time, the other visual of here's the stack of priors. Defense keeps making a big deal about all of these prior medical records, all of this prior treatment. Well, here's the little stack of paper, you're holding up, I think it was like, 30 or 40 pages of paper versus, hundreds of pages for the treatment that he's had after. And so showing the timeline and then showing just the physical documents, I think that was really helpful because when defense is talking about these prior injuries and reading from the medical records, putting them up on the screen, it seems really bad and seems like, of course, this is all from these prior injuries. But when you put it into perspective that way, it's really.
Oh, the visual aids definitely help. And that's those are 2 great ways to do it in your cases going forward. Well, Sarah, thank you so much for speaking with us. Again, congratulations to you and to Kurt and to your client. And we look forward to speaking with you soon.
Thanks. Yeah.
Take care.